If you were arrested for domestic violence, what you may realize or be realizing is that not everything is intuitive in how to handle these cases. And in fact, if you just try to rely on common sense and intuition, you may end up seriously screwing up your case. So in this video, which is part 7 in a series of 7 videos, I'm going to be going through a common misconception, a common mistake that people make so that hopefully you can avoid it in your case. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to represent yourself in a domestic violence restraining order hearing if you are also dealing with that in addition to the arrest, and win. So if that is a situation that you unfortunately find yourself in, there's a link to a free first class. You can get it in the description box down below. Okay, so let's jump right in. This is misconception number 7, which is taking legal advice from friends, family, acquaintances, instead of professionals. So basically what happens, you get arrested for domestic violence, right? And you get out of jail, you bond out, and you're wondering like what the heck to do. So you call a friend who maybe has dealt with false domestic violence accusations in family court, maybe has, been to prison or jail in their younger years, someone to help guide you. And that's normal. You don't know what to do. I mean, you're probably feeling a little bit lost. So you turn to someone who you hope has some guidance for you. Now, I'm not saying that it's a bad decision to call that person first and maybe get a recommendation from them for a lawyer, for example. But what I am saying is a bad idea is keeping that person as your confidant, as your guidance, above whatever attorney you hire. Or even once you've already hired them, insisting on things that your attorney should be doing. This is a bad idea. It's not just because it's annoying. It's because it can seriously derail your defense. It can lead to you making really, really bad decisions. Because this person knows basically just enough to be dangerous. They didn't go to law school, and even if they did, they're not a criminal defense lawyer. They don't have the experience with how this stuff works to be able to competently guide you. And they will advise you sometimes to take your case to trial. It's a he said, she said case. They don't have enough proof. They'll come up with motions that are really unheard of for most cases in criminal court that your attorney should be filing and insist on them. And overall, what they will end up doing is causing you to make bad decisions because they're eroding your trust in your attorney. And I don't care if it's a private attorney or a public defender, they are eroding your trust and your relationship with that person. And in criminal cases, as a criminal defendant, one of your jobs, the main thing that you're going to have to do is make a decision on when you take some kind of offer. It can be taking classes in exchange for a dismissal, keeping your record completely clean. And the alternative, generally, is going to trial. And so when you have somebody who doesn't really know what they're talking about, and especially when they think they do, whispering in your ear telling you, no man, it's a he said, she said, you got to take it to trial, you have to have your day in court. What will probably end up happening is you end up being confused. You're like, well, does my attorney not want to fight this case? Why are they telling me that I should probably take these classes in exchange for a dismissal? You are now conflicted. Instead of just having an experienced professional tell you, hey, these are your choices. You could take this offer or you could go to trial. If you take this offer, here are the positives, here are the negatives. If you go to trial, here are the positives, here are the negatives, here's what our case looks like, and here's what I think that you should do. Instead of hearing that and using your best judgment to probably follow your attorney's advice, but you don't have to, instead you have somebody whispering in your ear telling you other things, and you can end up making the wrong decision. All right, so let's give an example of this and see how it can play out, and we'll do our final choose your own adventure of this series. Tom, overwhelmed and confused by his domestic violence charges, calls his buddy, who he knows has faced domestic violence charges before. Now, Tom has already hired a lawyer, but he wants to get a second opinion on any advice that his lawyer gives him. At a certain point during the case, Tom is, in fact, offered classes in exchange for a dismissal. And there isn't a lot of evidence against Tom. It's really just his ex's word against his. His ex hates him, and she's a good liar, but it's basically just her word against his. Now, Tom calls his friend and he's happy because he can avoid a conviction if he takes this deal. But he just wants his friend's second opinion. And his friend says, you know what? That's a he said, she said case. That's BS. Your ex is lying. What, you're just gonna take that? You can't take that. No, until she is cross-examined, until you have your day in court, I don't think you should take any deal. Tom talks to his lawyer. His lawyer says, I think that you should take that deal. I mean, we have a good chance at trial. We have a good defense, but you've told me that she's a good liar, and you can be convicted based on just one person's word. So I think if we can eliminate the risk and you just take some classes and it gets dismissed, you should probably do it. Choose your own adventure. Choice number 1, follow your friend's advice. Tom rejects the plea deal based on his friend's suggestion, ultimately loses a trial because his ex is indeed a good liar, even though his lawyer is also good. The jury believes her, and he gets a 6-month sentence in jail. His friend does visit him, though. Choose your own adventure. Choice number 2. Tom decides that he's going to consult another lawyer. His lawyer, in fact, tells him that if you don't believe me, you're free to get a second opinion. Get a second opinion from someone. Just make sure that they are a criminal defense lawyer. Tom does exactly that. The criminal defense lawyer says, are you crazy? If you're offered classes in exchange for a dismissal versus going to trial against somebody you're telling me is a good liar, you should take the deal. Tom then decides to go ahead, take the deal. He does his classes, the case is dismissed, and he lives happily ever after. Now look, one of the messages here is if you don't trust your attorney, go get a second opinion. Just go and get one. It's not offensive to do so. Your attorney's job isn't to convince you to take a deal. It is to zealously advocate for you, present you with options, and ultimately you are going to have to make a decision. So when you're making that decision, just make sure that whatever you're taking in when you're deciding, when you're making this big decision for yourself, it's competent advice. Because the jailhouse lawyers generally think that they know a lot more than they do. So get your second opinion if you have to, sure, but don't listen to somebody who doesn't really know or hasn't proven to know what they are talking about. I hope you found this video helpful. If you do have a criminal case in California that you need help with, feel free to book a call with me. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.